Today's lecture continues our discussion of the European human rights system with a focus on the distinctive legal doctrines developed by the European Court of Human Rights. We will look at three of those doctrines and we'll see how they apply in a 2001 judgment of the Grand Chamber of the ECtHR in Chapman versus the United Kingdom. Let's start by identifying each of these three doctrines. I'll explain a little bit more about what each one is and how it functions, and then we'll turn to the Chapman case. The first of the doctrines that I would like to explore with you is known as the margin of appreciation. And I'll explain a bit more about what this means in a moment, but essentially it is a doctrine that gives discretion to national decision makers to determine how best to balance the rights and freedoms protected in the European Human Rights Convention against other important societal interests. The second doctrine developed by the European Court is the interpretation of the European Convention as a living instrument, that is, one that is not bound by any specific historical circumstance or understanding. The third doctrine, which is in somewhat tension with the second doctrine, is the weight that the European Court gives to its prior judgments and rulings. Once it's decided an issue, when, if at all, is it appropriate to revisit that issue? The margin of appreciation doctrine is that degree of discretion or deference that the court gives to national governments, so this would be legislatures, executives, courts, to all the branches in national governments, to decide how best to give effect to the rights and freedoms in the convention, in particular in cases where there are countervailing societal interests and more than one way of a state fulfilling its obligations. Over the course of more than 40 years, the European Court has identified a number of factors that are relevant to determining the width of the margin of appreciation. These include the right being reviewed and allegedly violated, the nature of the state's interest, and how substantially it has regulated the right in order to achieve that interest. These will be issues we'll discuss in more detail in the Chapman versus UK case shortly. The second doctrine is the ECtHR as a living instrument. And here the idea is that the court recognizes that human rights concerns and human rights violations may change over time. And so the understanding of what the meaning of general or open-ended terms were, such as due process, equality, privacy, expression, and so forth, that those terms might evolve in their understanding over time, and that the court would need to update its interpretation of those rights and freedoms in the light of present-day conditions. And therefore, restrictions or regulations on these activities that might once have been considered perfectly acceptable might later be found to be in violation of the European Human Rights Convention. How would this concept actually apply in practice? The idea here would be that at some point the court would take account of trends in national legal systems within the 47 member states of the Council of Europe, trends at the regional level, such as regional agreements, resolutions or reports adopted by other Council of Europe bodies, such as the Parliamentary Assembly or the Committee of Ministers, and other sources involving European public or expert opinion. And the court refers to these sources in determining whether the convention has been violated in quite a few cases. The third doctrine we'll consider is the precedential weight that the court gives to its prior judgments. Here, although the court, like other international tribunals, is not formally required to follow its earlier decisions, it generally does so for very, very good reasons. Foreseeability, similarly situated litigants being treated equally, and promoting equality before the law. So generally the court will not revisit an issue that has been decided. But there are some cases in which it does decide to revisit an issue that it's previously considered. That might be because there has been a change in the understanding of a particular right or freedom in the time between the earlier decision and a subsequent decision. All of these three doctrines that we've just discussed, the margin of appreciation, the living instrument idea, and the precedential weight given to prior decisions, are referenced in, and important to understanding, a Grand Chamber decision of the ECtHR from 2001 in the case known as Chapman versus United Kingdom. And the case really highlights the challenges that arise from the interrelationship of these three doctrines. You'll see that a Grand Chamber of the court, by a closely divided majority of 10-7, rejects the claim by a gypsy, a minority group with a distinctive traditional lifestyle, that a United Kingdom planning board refusal to allow her to station her mobile home or caravan on her land violates the right to respect for family life. And you'll see how that plays out when you read through the excerpt of the decision, which I invite you to do now. Please continue the lecture once you've reviewed the excerpt. Let's first review the facts of the case. So Ms. Chapman is a gypsy or a member of the Roma community who purchased a plot of land in an environmentally protected greenbelt in the United Kingdom. She moves her family onto the land and lives in a mobile home or caravan there for a period of time. She then applies for permission from the local planning agency to permanently locate her mobile home on this land. And the planning board ultimately, after considering the arguments that she raised, refused her request because the land was located in this environmentally sensitive area that was reserved or zoned for limited development. And eventually, as a result of that decision, Ms. Chapman and her family were evicted and returned to a nomadic or traveling existence. The key issue for the European Court is how to interpret Article 8 of the Convention. Now, there's no debate among the majority or the dissent in the Chapman case, and indeed no real debate by the UK government, that's the respondent in this case, that there has been an interference with the right to respect for Ms. Chapman's home. The real question that divides the court is whether there has been an interference that can be justified under the second paragraph of Article 8. And there are three key requirements that need to be shown in order for such an interference to be permissible under the Convention. The first is that the interference has to be in accordance with the law. There's not much dispute about that in the Chapman case because the United Kingdom has a set of rules that apply to planning board decisions, and they were followed in this case. So the rules that were applied were not themselves arbitrary or unexpected or unforeseeable. The question is, were they applied correctly? And to determine that, the court has to decide whether the interference, and I bolded this phrase, is necessary in a democratic society in order to achieve certain other interests. In this case, the interests focus on the protection of the rights and freedoms of others, those who have an interest in preserving the environmentally sensitive greenbelt in which Ms. Chapman would like to station her caravan or mobile home. The necessary in a democratic society test requires the court to consider both the strength of the government's interest and the proportionality of the regulation that gives effect to that interest in restricting individual rights. Now, that question is one that comes up before the court in many, many cases, and one of the ways that the court tries to answer this question is by turning to the three doctrines that we've been discussing. And this raises the obvious question about how these three doctrines play out in the context of the Chapman case. And I think I would submit to you that they interact in some of the following ways. Let's start with the weight or precedential authority given to the court's prior judgments. You may have noticed that there was an earlier decision by the European Court involving much the same issues. This was the Buckley versus the United Kingdom case, also involving a gypsy individual who attempted to place a caravan on land that was zoned for limited development. And the court rejected that case some 5 or 6 years before the Chapman case. So you might think, well, why would the court then revisit this issue in 2001? One reason why the court does revisit the issue is because of claims by Ms. Chapman's attorney that there have been developments, the evolution of a European consensus on the protection of national minorities, which includes the gypsy communities. And so you have a situation in which the law and policy at the regional level may have evolved or changed over time. The third doctrine, the margin of appreciation doctrine, is also involved in the Chapman case. The court gives the United Kingdom a fairly wide margin because it believes that the planning board is in a better position to determine how best land should be utilized as compared to judges sitting in another country who are much less familiar with those local circumstances. Now, the court is quite careful to not give too much discretion, I think, to the government, and this was a close case, in part, as you can tell by the opinion of the 7 dissenting judges who would have found a violation of Article 8's right to respect for a home. The challenge facing the court was that the doctrines seemed to point in different directions. The margin of appreciation doctrine tended to favor the government because this was a local land use issue. The European consensus inquiry tended to favor the applicant because there was a new framework convention on national minorities and other resolutions by regional bodies suggesting a growing trend in favor of protecting the traditional lifestyles and cultures of national minorities. And there was an opportunity to reconsider some of the earlier decisions the court had reached by a full grand chamber, that is the largest body in which the European Court of Human Rights sits. Ultimately, I think the court determined that the applicant, Ms. Chapman, and her attorney had not demonstrated persuasive reasons why the caravan needed to be stationed on this particular piece of land, and how the stationing of that caravan related to her traditional lifestyle. In the absence of that evidence, and concluding that the evolving views about the protection of national minorities were still in fact changing, they had not yet crystallized, and they were still quite general, the court determines that the United Kingdom had not overstepped its margin of appreciation, and thus that the regulation at issue was necessary in a democratic society within the meaning of Article 8, Paragraph 2 of the European Convention. I hope you'll see why this is such an interesting case, why it raises some fundamental challenges for any human rights court that is going to update its understanding of human rights over time in light of current circumstances. And I invite you to take a look at some of the sources that I've listed on this slide, which will give you other examples of other cases and other topics in which the European Court of Human Rights has wrestled with similar issues.